The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. We want to welcome everyone to the Fourth Circuit this morning. We have three interesting cases and a host of good lawyers. And we'll call our first case Kale versus Scott. Mr. Manius, good to have you with us, Mr. Manius.
Good morning, Your Honors, and thank you, Your Honor. My name is Brad Banis. I represent the appellants in this case. 1976, Congress amended the statute, 8 U.S.C. 1255A. Colloquially, this is the statute that creates a benefit called, most people call it a green card. They eliminated the requirement that at the time of approval, a applicant's priority date, the date where they filed the application, be, quote, immediately available under the Department of State's Visa Bulletin. This wasn't arbitrary. This was from 25 years of experience in trying to work through different iterations of this requirement. 1952, they required a visa to be, quote, immediately available at filing and approval. 1965, they changed it to just having that requirement at approval. In 1976, the House report makes it clear we are finally going to designate and decide whether a visa is immediately available at filing, and once it's filed, we're going to make a decision. The agency hasn't passed a regulation, hasn't amended the statute. Instead, they've continued to apply the policy that Congress repealed through sub-regulatory acts, through sub-regulatory guidance. And so we do not challenge a regulation. We do not challenge a statute. We challenge the agency's refusal to make a decision on my client's applications. For that
What
reason,
is the ultimate remedy you want? Let's assume we get past the jurisdictional problems. Let's assume we get all the way to final judgment in this case. What is the remedy you want from the district court?
I'd like them to compel a decision on my applicant or my client's green card applications.
And what if the decision is there's no visa available for your clients because the State Department limits the number of visas and you're not at the front of the line? What if that's the decision?
That would be an unlawful denial, Your Honor. And if the agency put them in removal proceedings, they would challenge that. That would be a legal question. This court would clearly have jurisdiction.
So the problem is it just seems to me that you want one of two things, neither of which seems tenable. You either want the court to order the executive branch to issue more visas than Congress has authorized the executive branch to issue, or you want your clients to jump the line in front of people who filed before your clients.
Your Honor, I don't want either of those things.
Okay, explain to me how you can get what you want without doing one of those two things.
Absolutely, Your Honor. The statutory terms are available and immediately available.
And then there's a statute that says how many visas can be issued, right?
That's correct. That statute, 8 U.S.C. 1152, defines the numerical limitation of the total number of visas that are available in each fiscal year. Today, where we sit, there are tens of thousands of visas available under the second employment-based preference because they haven't run out of visas for fiscal year 2025 yet. Those visas are available.
Okay, but isn't it the case that there are more people who want those visas than there are the number of available visas?
Yes, there are, Your
And
Honor.
aren't there more people who want those visas who filed earlier than your clients?
And later than my clients.
It doesn't really matter about later. I'm just saying, basically, again, it seems to me that you either want to increase the number of visas or you want to jump the line, but I don't see how you're not asking a court to give you the ability to do one of those two things.
Well, Your Honor, there are visas available, and I don't think my opposing colleague would disagree with that. So the Department of State's already made a decision, Your Honor, that my clients are at the front of the line. They did that in 2022 by saying we are providing green cards and immigrant visas to people who filed up through December of 2014. That was the Department of State's decision, and I'm asking this court to respect that decision and the agency to respect that decision. My clients filed in August of 2014, and so there are visas available. They are approvable. The statute, nothing in the statute, the regulations, or the policies require there to be a visa bulletin date that is later than my client's filing date at approval. That's what we're here to discuss. And the agency, Congress rejected that, repealed that requirement. The agency just never changed their position. I believe in the record there's a memo from Legacy INS, right? INS is no longer around, that says, we recognize that Congress changed this. We are not changing our position. And that probably would have been the appropriate time to challenge this change in policy. However, it didn't happen. I wasn't born yet. And today we are in an unprecedented situation where the agency's policies, this policy in particular, is the cause of this backlog that for Indian nationals, for my clients, if they have to wait, it is not hyperbole to say they have to wait another 20 years for an immigrant visa. Even though the statute says there doesn't have to be an immigrant visa immediately available at approval.
So can I ask you to talk about the jurisdictional question?
Yes, Your Honor.
So why isn't, in the complaint you say USCIS is issuing letters indicating that their adjustment of status applications can no longer be decided because they're subject to the adjudication's hold policy. That's directly from your complaint. Why isn't that a judgment or decision within the meaning of 8 U.S.C. 1252A2B?
First off, there is, I call it a policy, Your Honor, but it is not embodied in the statute or regulation or even.
Well, but they told you it's not. So I guess I'll say it's not. In some cases where courts, including this one, have said you can sue to challenge in action. I'm thinking of some FOIA cases I guess I've sat on where you like submit a FOIA request, and a month goes by, a year goes by, 3 years goes by, and you hear nothing back from the agency. The agency just, as far as you're telling, may have forgotten you or be ignoring you. And we say you can bring action, as sort of action to compel them to do something. That's not what they did here. USCIS gave you an answer to what they're doing. You just don't like the answer they gave you, but that sounds like an action or a judgment. They've decided they're not going to do this until X happens. Why isn't that exactly the kind of thing you're not allowed to challenge?
Well, 1252A2B also requires that judgment to be discretionary. This is not a discretionary choice. The agency's litigation position has been that they're exercising discretion here. But the facts are that the agency sees this as a legal eligibility criteria, and they are, like in this case, this court's case of Perez versus USCIS, they've added something to the statute. They've added this requirement that there be a visa immediately available at approval that Congress repealed. So to your question, in the Lovo case that came out last year, I believe it was Judge Davis said, we can't define action to mean inaction. In here, we cannot define.
You said it's a litigating position, isn't it? Isn't it in the USCIS policy manual?
No.
Volume 7, Chapter 6, Section C5.
Your Honor, I'm not going to doubt that specific site, but
That's not a litigation position then, right? If it's in a policy manual, it is not merely a litigation position.
Your Honor, if you look at the documents attached to the motion to strike that happened last week, you will see the agency's actual position here. That actual position is that they will deny naturalization. They will deny naturalization if someone acquires permanent residency based on a visa that's not immediately available, because they say it's a legal requirement. There are two decisions in there where the agency is rescinding green cards because they, under their own policies, jumped the gun and made a decision before the visa was immediately available.
To agree with you, would we have to split with the 1st, 3rd, 5th, 8th, and 9th circuits on this question?
And the 11th. They
Great.
ruled against me last night. I would say this, the 9th Circuit didn't get to the jurisdictional issue.
Okay, maybe we'll tentatively mark off the 9th. So how about the 1st, 3rd, 8th, and 11th?
The First Circuit assumed jurisdiction,
Cool.
so you are
How about the 3rd, 5th, 8th, and 11th?
3rd, 5th, 8th, 11th. Yes, Your Honor.
And how many circuits have agreed with you?
None, Your Honor, not until this one.
So we'd have to create a circuit split.
Your Honor, yes. And I think when I'm asking you to make the right decision, I think that's this court's role. This court has an independent
Well, you're
duty.
entitled to ask for it, there's no question about it. I mean, yeah, if you're right, maybe that.
And I think the Fourth Circuit has different law than the 5th and the 8th
Get some back
and
to
the
it.
3rd.
What about these, he mentioned that motion to strike. Is any of that stuff in the record in this case?
It's not in the record, no, Your Honor.
So there's a provision in Rule 10 that lets you supplement the record in limited circumstances. Otherwise, the record on appeal's fixed when it comes up here. And we don't often supplement records on appeal. We look at the record as the lower court. Here, Judge Flanagan had a record. She decided the case. You want us to decide the appeal based on a different record. Why would we want to do that? Wouldn't be fair to her.
Well,
Wouldn't
Your
be
Honor,
fair to the lower court ever to do that. I mean, issues are supposed to be presented and then come here for review, and on the same record.
and Your Honor, I would respond to that in two ways. First is that this case was dismissed at the 12B stage. I made allegations that that they consider this a legal requirement.
Yeah, but you didn't even do it right. I mean, I'm saying you didn't make a Rule 10E motion to supplement the record. You just slapped it on the back of whatever you call it, the motion to do something.
Your Honor, we are asking the
Motion to
court,
file.
we are asking the court to take judicial notice. The
No,
court,
take judicial notice.
the
There
court
you
can
go.
take
That's what-
judicial
that's-
note- I'm
That's
sorry.
your alternative request on that, was they could take judicial notice.
in our response brief, that's our only argument. And we would suggest that judicial notice can be taken of something that's undisputed, that's on a court record, and where the other party has fair notice of it. These are documents that USCIS itself issued. They are defendants in the lawsuits where these are in the record. And I don't know how they can credibly dispute that these exist and this is their position. And so I understand, Your Honor, you would prefer me to move to supplement the record. I don't think I could have brought it, to the extent in my complaint, my job is to allege things with good faith. I alleged this, and Judge Flanagan, I would argue, violated the Rule 12 standard by not assuming it was true. These documents from just the past couple of weeks, Your Honor, demonstrate
They
that
weren't before Judge Flanagan.
they weren't. No, Your Honor.
That's right.
Our allegations
That's my
was.
point. They weren't before Judge Flanagan. You want us to decide these issues on something that she didn't have presented to her.
Your Honor,
And the appeal is from her decision.
That's correct, Your Honor. And I would suggest that I didn't know the government would misrepresent its position in federal court. And so I didn't think it was necessary at the time of the case.
Counsel, maybe help me a little bit. You would agree that if your client had been out, just straight out denied, we wouldn't have jurisdiction to review that?
Your
If
Honor,
they said no, I mean, just keep my question is very simple. Let's try to keep it simple. If they had said no to the visa, green card, we wouldn't have jurisdiction to hear that, right?
under this court's recent decision in Shaiban, I think that's right.
Okay, all right.
However, this court would have jurisdiction to review it if the agency would follow its current policy of when they
Yeah, okay,
deny.
well-
I'm sorry.
No, okay, but I haven't got to that point. Okay, we got that. Now, so you're saying really that for you to get the jurisdiction, you'd have to say that we're allowed to hear a case where they abuse that discretion, right?
Your Honor, I think that there's no discretion involved here.
It has to be somewhere. It's pretty clear in terms of that's their job to do that. That's really an executive function of government. It's not judicial until it gets to the point where we have a window to jump in. But we just admitted that if they just outright and said, no, we don't have discretion. And so if they give you that's the worst thing that could happen to you. They say, no, if we don't have discretion there, then you got to back it up something less. Is that less a remedy based on abuse of discretion?
Your Honor, two things. If we look at the statute 8 U.S.C. 1255A,
I'm looking at the statute. The question is, do you have to establish or make a case of abuse of discretion for us to have jurisdiction to hear this case, to grant the relief you want?
no, Your Honor.
Or we don't? Or they don't?
I
Okay.
don't think you do.
So how do you do the end around where we don't have discretion to help you if you lose completely, but somehow in the process, we do have jurisdiction without your showing any abuse of that discretion?
So to get in front of this court under Shaiban. They would deny the application, they would put my clients in removal proceedings, and then we would come through a petition for review.
Oh, absolutely, yeah.
Yes, Your Honor.
This is not the end of the, whatever happens here today is not the end of the road. I don't know what's gonna happen because we haven't decided, but there is a process where you can come into court, but you're not there.
Well, Your Honor, if CIS denies this, it would be an unlawful denial, not a denial based on discretion. If you look at the agency's own regulations, it's 8 CFR 103.2. They identify a class of decisions that have two parts to it. One is the legal eligibility, and then the other is the discretion eligibility. This is a legal determination. And so under the Supreme Court's case from last year, Wilkinson, that recognized that Patel was limited to factual determinations, it said we can look at mixed questions of fact and law under 8 U.S.C. 1252 A2 D2, and they recognize jurisdiction over it 100%. This would fall into that category of cases. I see my time is up, so I will sit down
Thank
unless
you
the
very
court
much.
has other questions.
You've
Thank you, Your
taken
Honor.
some time. Ms. McTeague?
Good morning, Your Honors. May it please the court, Alexandra McTagg, on behalf of the government. The district court was correct that there is no jurisdiction to review the appellant's claims in this action, and this court should affirm that decision. The appellants are challenging this retrogression hold policy, where they say that USCIS's decision to allow an application to remain pending when visa numbers retrogress is inaction, not action, under 1252 A2B, and should be reviewed by this court. But in fact, USCIS's decision is discretionary. It falls within the discretion granted to the Attorney General or the Secretary of Homeland Security under 1255A, which says that status may be adjusted in the discretion of the Attorney General or Secretary of Homeland Security under such regulations as he may prescribe. And so what we're dealing here with is a particular scenario within the visa allocation system where applicants have a priority date, they understand from the State Department's estimates that they are current, they apply for adjustment of status, and while that application is pending and being adjudicated, it turns out the estimates are wrong and the numbers, the priority dates move backwards. USCIS can't grant that application without a visa because there are limits, statutory limits on the total number of visas, on employment-based preferences, and they can't allow people to jump the line because visas are to be allocated in priority date order. And so they have a decision. They could deny the application, or
Which arguably would be more consistent with what the statute says, right? I will just get, when I read this the first time, I thought, the statute seems to say you can't even take their application until there's a visa available.
And so we would say that that is one of the reasons that this is a discretionary decision that they've made. They created a third choice here: grant, deny, or allow it to remain pending when there is not some other reason to deny it until a visa becomes available. This is not a case of inaction.
I mean, doesn't, the statute says the visa has to be available at the time of application, right?
It does say that there should be a visa immediately available at the time
Not,
of
there should be, it
application.
says there has to be, right?
Yes.
So, I mean, in some ways, a literal reading of that suggests that if there's not a visa available, you just have to deny the application at the front end, because denied, there's no visa available.
But they don't accept the applications if the priority date is not current.
Can I ask you, just flip this around, and then but then it changes and it retrogresses back. Do you agree with at least at a high enough level of generality, do you agree with the plaintiffs that there is a statutory obligation to eventually adjudicate every adjustment of status application that's filed?
A statutory obligation, no, Your Honor.
You
No.
could just sit on them forever?
So 1255A says that the adjustment process is discretionary to the Attorney General in the regulations that he may prescribe. And there is nothing in 1255A that actually says what that process must be or what must actually happen. And the First and the Ninth Circuits have looked at that and said it doesn't prescribe any details of the process. 1255A doesn't say a decision must be made. This is a discretionary decision.
But isn't
about-
that implicit? I mean, that just seems extraordinary and bizarre to say that you can have a process where people submit applications, but there's no duty to decide them ever. right? That we will receive your application. What I will do is I will take your application, I will put it in a file, and then I will never look at it again. That would be, in your view, an acceptable approach under this statute.
That's not the approach we
Or
have.
I'd shred it. I'd put it through a shred. Like, I've accepted your application. Here's the shredder. I'll walk it over to the shredder. I'll place it in the shredder. And that's something we can do?
Your Honor, they haven't identified.
I'm not saying that that's what's happened
a
here.
duty, right? Correct, and it's not what's happened here, right? This is not a case of inaction. This is a case where they actually took these applications in. These folks.
But that's a
had
different argument.
metrics.
I first asked you if there is any duty to do anything ever, and then you're telling me that's not what they're doing here, which, to be fair, I'm not suggesting it is what we're doing here. But I'm asking you the threshold question of, is there a duty to do something eventually?
There is no duty under 1255A to, for the Attorney General to grant any.
Let me rephrase that.
status.
Do you think that under our precedent, we would have jurisdiction to consider a pure inaction claim?
I think
we've said
under-
that we do. A pure inaction claim.
A pure inaction claim, I think, under your precedent, so under Lovo suggested that the meaning of action under 1252 does not include inaction. And so Lovo held that if there were a duty, then you could have jurisdiction over.
We'd have jurisdiction. Now, we might decide there's no duty, but we would have jurisdiction to consider that claim under Lovo.
If there were no duty to make a
No,
decision,
but
then
so
there'd
this
be
is
no
where I'm getting,
jurisdiction.
you brought me to, you make this standing argument in your brief, which strikes me as fatally confusing standing with the merits. You're saying, like, there's no standing because it's not the executive's fault, it's Congress's fault. And then I think, yeah, but ex parte Young, like, we have all kinds of legal fictions where the executive branch could say, it's not our fault, it's the legislative branch's fault, or it's the judicial branch's fault, or it's the state's fault. And I don't know, ex parte Young says that's not a standing problem, right? If it's a problem, it's a merits problem, but that's not a standing problem.
Well, so I would say here it is actually a standing problem, because the problem is that there is no visa available to these individuals because they're not at the front of the line. And that is the problem with why they have no standing.
Because it's not redressable, in your view?
Because
Like, put this into the language of Lujan. How is that a standing problem?
it's both not traceable and not redressable. It's not traceable because the problem is the limits of the visas available. It's not that USCIS has, independently decided to stop doing something. It's that they can't do it because there is no visa available to these folks. So it's not traceable to USCIS because there's just a
I
problem
just feel
with
like
the
I could
visa.
instantly come up with like dozens of examples where the executive branch could argue the same thing, that there's no standing. Like, the legislature passes a discriminatory tax and someone files suit to challenge that, and the executive branch says, look, it's not my fault that we have to charge you more than your neighbor. The legislature has told us we have to charge your neighbor less. I can't fix the problem. I am but powerless. And no one would take seriously that being a standing problem.
But I think it's also not redressable, right? Because a decision by this court isn't going to get the appellants what they want. Now, Mr. Banas is up here saying, well, they could end up in removal proceedings. But it's not clear to me that the appellants are actually seeking to end up in removal proceedings. Right now, they are in a lawful, an approved status within the United States. They have the ability to apply for work authorization, and that work authorization allows them to switch jobs, and it also provides them with travel authorization.
How is that a standing problem?
No, but so what I'm saying is that if this were redressable in the way that the appellants want, they're really looking for a visa, right? They're not looking to lose all their benefits. They're looking for a visa. And the reason you're saying that my standing argument is intertwined with the merits is because of this merits argument that has been made about you have to allocate a visa when the application is filed.
Right, and maybe they're right about that, maybe they're wrong about that. I'm not, for purposes of this question, saying whether they're right or wrong about that, but that's a merits problem, not a standing problem. If it's a problem, that's a merits problem, not a standing problem. Or at least,
Okay.
I'm predisposed to think that's a merits problem, not a standing problem. If you would like to try to convince me why that's a standing problem, but I'm genuinely not understanding why that would be a standing problem.
And so, from our perspective, it's a standing problem because it's not truly redressable in this case.
But they allege it is redressable. They say there are, in fact, visas available, and you say, no, there aren't, because Congress limits them. And again, maybe you're right about that, maybe they're right about that, but that strikes me as a merits problem, not a standing problem.
And I do think the two are intertwined in the way that they have framed this case. And going to that, whether visas are available, just because there are visas made available every year by the State Department doesn't mean that they are immediately available to these applicants, because again, we have an issue of priority date order. The visas are supposed to be allocated in the priority date order. And the entire problem here, Mr. Manis said that the State Department made a decision that these folks could file their applications, but what the State Department made were estimates. The State Department estimated how many visas were going to be available, how many people they thought might apply for them, and what the priority date cutoff was going to be. When they make those estimates, they're taking in information not just from adjustment of status in the United States, but from the consulates around the world. And those are just estimates, they're not guarantees, they're not decisions on a particular applicant. And so those estimates sometimes turn out to be wrong, and that is what has happened in all of these cases. The estimates were wrong, and the dates retrogressed, so the applications couldn't be approved. But there's no decision that was made here by the State Department. There's just nothing available for these folks right now. And that's why their applications can remain pending until a visa becomes available. And we believe this is a case of no jurisdiction under 1252A2B2. This is a decision or action by USCIS that is discretionary to allow these to remain pending. It's also could be under 1252A2B1, that it's a judgment regarding the adjustment of status applications.
So you want us to dismiss, or say the district court was correct in dismissing, is that correct?
Yes,
You
Your
want us
Honor.
to affirm the district court?
Yes, Your Honor.
And what do you want us to do with this Appendix A that the other side submitted?
I'm sorry, Your Honor.
These other documents that are subject to the motion to strike.
So we don't believe the court should consider them because they're not part of the record. We also don't think they're appropriate for judicial notice, as the appellants argue, because they're not relevant facts. It's about people who are not involved.
Your position is we need to grant the motion to strike and affirm the district court.
Yes, Your Honor.
Wait, hold on, you said two things. You said they're not appropriate for judicial notice,
Yes.
which is an argument, that there's a lot, but then you said they're not appropriate for judicial notice because they're not relevant. That strikes me as a different argument. Like, it strikes me if something isn't appropriate for judicial notice if it is not a widely available fact whose reliability is not subject to reasonable dispute, not, they don't matter. I mean, they don't matter just seems like you shouldn't consider them because they don't matter, but that's not an argument that you shouldn't consider them at all. Or I guess, it's not an argument that you should strike them, it's just an argument you should ignore them.
So, Your Honor, I believe under Federal Rule of Evidence 201, judicial notice applies to adjudicative facts, which are facts that are relevant to the particular dispute.
I'm not sure it matters where you ultimately end up, right?
No, I think you can get beyond that because these are documents that some of them are redacted. They pertain to people who are not in this litigation. They pertain to issues that are not in this particular litigation with different facts. We don't really know what all of those facts are based on the documents presented. The plaintiff or appellants have not identified particular facts within the documents that they want judicially noticed. I mean, they have the burden on that. Just because they were attached to a court filing doesn't make them the type of document that you would judicially notice. You may judicially notice a court's docket, for example, but that doesn't mean that every statement within the filings of that docket is something that could be judicially noticed. So from our perspective, there are a lot of reasons why judicial notice is not the right way to go. And so, yes, we think the motion to strike should be granted. The district court's decision should be affirmed. There is no jurisdiction to review this because it is a discretionary decision by USCIS. And we also think on the merits, this idea that a visa should be assigned at filing is just not supported by the statute, which doesn't talk about, or I'm sorry, that it has to be assigned at, yes, that it should be allocated at filing, just isn't supported by the statute because the statute doesn't require that. And in fact, 1255B says that the State Department shall allocate a visa when an application is approved. So when you read the two together, it really is the case that visa allocation isn't at the front end. Not to mention that Mr. Banis relied on a 1976 amendment, which has now been in place for over 50 years. And so Congress has never sought to change this language since then. And so we would ask that you affirm the district court's opinion, and that there's no jurisdiction. Unless there are any other questions.
Just one question about, and understand you, in the stopgap you have is you allow certain things to, benefits to occur, like changing jobs and even traveling, those things. Is that automatically given while you're waiting in the queue?
It's not automatic. Those are things they would have to apply for, but they're eligible to apply because they're waiting in the queue.
And that's another level of discretion, whether or not you give that?
I confess I don't know the details of how those things are processed.
Well, what about, your learned colleague said it could be 20 years waiting. Is that true?
Your Honor, I don't have any way to know exactly how long this is going to be since it's all based on State Department estimates. I can say that over time, the priority dates do generally move forward. I did check them last night. And so at this point, in March, the final action dates were December 2012 and February 2013. And then in April, the final action dates will be January 2013.
So just so we're clear,
and
that
April
means
2013.
that we are currently granting visas. These are people from India?
Yes,
So we are currently granting visas for people who applied 12 years ago?
I think that's right. And these, the appellants applied in August of 2014. So they are still off of the final action dates for EB2 or EB3, but they're not that far off at this point.
Am I correct also that a person, hypothetically, that a person could be near the point where they're about to get their visa, that the State Department could decide that we're not going to give any visas to that country? Is that right?
I don't know exactly what the State Department decides about visas to particular countries. I do know that we're talking about visas to India.
But you
here.
do know that you have to take orders from the State Department as to how many. Like, for example, some countries have very few or little at all, right?
Well, so the worldwide limits are set by Congress, and then within the worldwide limits, there are per country limits. And then.
But can't the State Department change those limits per country when they want to? For example, based on what's going on in the world, can they say, you know what? We had allocated some for that country, but right now, zero. Am I correct?
I honestly don't know the answer to the question, Your Honor.
Oh, okay. So we don't know what level of that is.
Well, because it's not the issue in this case, right? We're not
It
facing.
may or may not be. You're talking about a powerful thing when you say that we don't have jurisdiction. Article 3, we have to look at that very carefully on both sides. One, so we're not over our skis and where we are, but also that people are not prevented from coming to court to seek relief. It's a sword and a shield. So that's
But
important.
I think your hypothetical would really be involving a different statutory section. It would be about allocating visas. And so, right here, we're talking about adjustment of status.
But it's the sine qua non for the people who are trying to get a visa. I'm going to ask the
understand
question
that.
whether or not there's an overriding situation where you say, I don't care what you're doing, no more visas from that country. Isn't that right? I think the State Department can do that kind of thing.
I don't know.
Okay, all right.
I'm sorry. I don't know the answer to that. But I can say that when we're talking about adjustment of status, Congress saw fit to say that the adjustment of status decision just is in the discretion of the Attorney General, and it falls within 1252A2B and isn't reviewable. And so when we're talking about that issue, which is the issue here, it's a question of jurisdiction, and there is no jurisdiction to review that decision.
You said Attorney General, did you meet the Secretary of State?
The Secretary of Homeland Security, I'm sorry, Your Honor. Because the statute says the Attorney General, but then the Homeland Security Act delegated that to the Secretary of Homeland Security in 2002. And so, although it says Attorney General in the statute, typically we're talking about the Secretary of Homeland Security who's ultimately making these decisions. If there are no other questions? Thank you, Your Honor.
Thank you very much. Mr. Banis?
Thank you, Your Honors. Judge Heighten's 8 CFR 245.2A5 mandates the agency make a final decision on adjustment status applications. This court should look to Gonzalez's 2020 opinion, where a panel looked at a regulation and said, this is a mandatory duty regardless of what's in the statute. The Norton v. SUA problem, or Southern Utah wildlife, it's not an issue in this case. They've conceded that in other courts. I'm unclear why they're not conceding it here. 1255A uses the term, it's 1255A3 actually. A1 says it's required to send in an application. A2 says you got to be eligible. And A3 says you have to have a visa immediately available at filing and filing only. So that's it. So there's no dispute that there was a visa immediately available, meaning their priority date was current at the time they filed their application. And I can tell you, there are people with priority dates from December of 2014 who currently have green cards today, but my clients don't. So this idea,
Wait, you said you can tell me, is that in your complaint?
it is in my complaint,
Okay,
and I've represented them.
okay.
The idea that the metaphor of a queue, of a line, is completely factually inaccurate. They do not decide these cases in priority date order. The fact that my colleague would come up here and actually represent that to a court is troubling to me, because that is well known. And they don't have to. Once they announce December 2014, that means they just have to make decisions on applications that were filed before that. And I do think, though my colleague wants to give no credit to the Department of State's decisions, that is a decision. They announced this, and they, by announcing it, triggered 1255A3, and 1255A does not say you have to be current at approval. This idea that it's an act of grace to keep these applications pending after retrogression is good description. It's good argument, but it's not accurate. There is no statute, regulation, or policy that requires a visa to be immediately available at approval. The policy guide section you cited, Your Honor, does not say an immigrant visa has to be immediately available at approval. And I know the statutory terms of available versus immediately available seem like they're the same thing. They are not. They are distinct legal concepts. So this is not an act of grace. They can't deny them because they don't have a legal basis to do so. That's why their entire brief is about jurisdiction, right? And 1252A2B1 and A2B is entitled Judicial Review of Discretionary Denials and Approvals. Discretionary. This is a legal requirement. The documents attached to the motion to strike.
Can I go back to this document again? All right, so I now have the language in front of me.
Okay.
I'm going to read you the following words and tell me how they don't address the
Yes,
thing.
Your Honor.
If an officer, this is, again, USCIS Policy Manual, Volume 7, Chapter 6, Section C5, quote, if an officer encounters a case in which a visa was available at the time of filing, true here, but is not available at the time of final adjudication, they represent true here, the case should be retained, pre-processed, and adjudicated to the point of final approval.
Your Honor, that talks about availability, not immediate availability, i.e. current. You
Okay.
can laugh
explain
at
to me
that.
why, yes, explain to me why those things mean different things.
Because available is an estimation of how many visas are available for this fiscal year.
No,
Typically,
no,
it's
wait. Available isn't an estimate. Available is available. Like, is something, if I walked into a store and I said, is something available? They would say, well, we estimated that it would be here today, but it's not here. So in other words, it's not available. Because when I ask you, is it available? What I'm asking you is, do you have one right now?
I 100% agree with you, Your Honor. I misspoke. At the beginning, on October 1st of every year, there are 140,000 visas made available. In other words, in the visa store, the shelves are stocked with 140,000 plus some, okay? That is a different concept, a different legal principle than whether my client's priority date is immediately available. In other words, are they allowed to go into the store? They're allowed to go into the visa store when the Department of State announces, hey, the shelves are stocked, they're available, and for you, with your priority date, they are immediately available. Our proposal, which Congress agrees with, is that once you're in that store, you can have any visa that's on the shelf as long as it complies with the overall caps availability and the country caps. India gets about 7,000 visas a year. I think in the 2 months when this priority date went forward, I think like 80,000 people applied. It's going to take a while to get through. But refusing to decide applications once they're in the store and when they are on the shelf, and I don't think my colleague disagrees that they are on the shelf right now. There are visas available. If the visas are not available, if they run out, which is what happened in 2022, which is what catalyzed these cases where I've traveled around the country without much luck, then I agree, they can't do anything. But on October 1st, they become available. And right today, under the law, you can only do 27% per quarter in the fiscal year. We are in the third fiscal quarter, and so there are, by definition, visas available. And I see my time is up. I appreciate this, y'all humoring me this morning, and thank you so much.
Good to have you with us. We'll come down and greet counsel and then go to the next case. All right, Ron? Yeah. Mr. Esponte? Good to have you with us, Mr. Esponte.
Good morning, Your Honors. May it please the court. My name is Jose Aponte. I'll be representing Mr. Julio Alvarado Bond this morning on our appeal from the United States District Court. The appeal specifically addresses two issues that were decided by Judge Locke in that honorable court. There was a motion to suppress that was filed by myself for my client. The issues when they were decided was that the search of the residence was based under voluntary consent given from my client. In the alternative, the court also said that the officers were within their rights to proceed to a protective sweep based on the information that they had before them. I will address each of the issues.
And when you said there's two issues,
Yes, sir.
these are related, right? In the sense that for you to win, you have to win both of them. For the government to win, the government only has to win one of them.
That's correct.
Okay,
Your Honor.
thank you. Just want to make sure I,
To be clear, I would have to show that first and foremost, consent was not voluntarily given by my client. In that case, the government that has the ability to say, well, if that's the case, the officer still proceeded in under a protective sweep. I'll take them both in order. With respect to the consent issue, the question is very simple, is whether or not my client provided consent for the sweep or the search that the officers did preliminarily. I'm not gonna try to rehash the entire information that's in the briefs, but there was information received by the police about a potential quote-unquote mass shooting. And this was in a time when there was much hysteria around this, and I certainly understand there was heightened alert on the part of police. The police received information about a potential address and identification of this individual that was received based on the informant tip that was
so
called.
can I move us forward? Because your brief spends a lot of time on this too.
Yes,
but
sir,
do you agree with me? The going to the front door, you have not challenged that, and that doesn't implicate the Fourth Amendment at all.
Correct,
You don't disagree that a person let them into the apartment.
no question.
So I guess what I'll, skipping to the end, by the time at the moment the officers are standing inside the house, the Fourth Amendment literally has nothing to say about anything that happened up until that moment.
100%, Your Honor.
Okay. So the only question is if in that moment your client consented, and if he didn't consent, whether the officers are allowed to do it anyway, right?
That's correct.
Okay. You also agree that this court has said consent is a factual finding reviewed for clear error?
That's correct, Judge.
So why was Judge Locke clearly erroneous in concluding that your client consented?
And Judge, and this is what I think is important with respect to the facts of this case. We are dealing with individuals who are not native English speakers. And we know that because not only do we have the officers that are there to investigate, we also have a third officer who's a native Spanish speaker because they know they are dealing with Spanish speakers. I think that becomes an issue, and I'll tell the court why. When we get to the point in time, as the court said, they've come in, there's no question, it was a knock and talk. My client let them into the residence, they're standing in the living room. When Detective Kinnery tells Officer Ferreras, let him know we're gonna go look for other people. He doesn't ask, he doesn't inquire, he says, let him know we are going to do this. At that point, Officer Ferreras translates that bit of information, says, hey, we are gonna go look for other people. And this is, the key part is my client says, yeah, go ahead and check. That's the first part of the sentence.
And he gestures.
Yes,
Judge Locke finds he gestures.
Yes, he does find that there was a.
Okay, well, that seems pretty important, because if a person says, we're gonna do something, and I say, that's a key part of whether I'm agreeing to what they've just said they're gonna do,
Judge,
right?
For our discussion, that's correct. I'll concede
He
to
not
that.
just gestured, he nodded.
I think, Judge, he kind of
Well,
directed
it
towards,
says,
towards the back of the.
Go check, and nodded and gestured toward the area
Yeah.
to be searched with an upturned hand.
Judge, and I'll tell you, looking at the videos, I was more focused on the hand and the gesture as we were watching this throughout the preparation. But what's important, Judge, is immediately upon that, he says, but my understanding is that in order for you to search, you need a warrant. And that's a key point, because Officer Kinnery says, we're gonna go look. Officer Ferreras translates that bit of information. My client says, go ahead and check gestures, and then he says, but my understanding is, Detective Kinnery has already gone. Detective Kinnery is already looking for whatever it is he's looking for.
Well, okay, I take your point on that, but why wasn't he entitled to do that? Because your client had said, go check, and gestured. At that moment, the searching officer is entitled to start searching, right?
Judge, but the point is, there is no translation of what is said by my client.
He gestures. I don't need to translate what a gesture and a nod means. A gesture and a
Judge,
nod means a gesture and a nod.
Respectfully, I disagree. I think that.
Well, you might, but why was Judge Locke clearly erroneous in
Because
concluding that that's what it
I think what's
means?
important, Your Honor, is that in the very next, when my client says that to the officers about the search warrant, Officer Ferreira says, we're gonna check regardless, is that okay? And the sergeant asks a question but doesn't finish, is he acknowledging? So there's some kind of discussion going on between Ferreras and my client in Spanish, the sergeant who's not doing the protective sweep about what is just occurring in that dialogue regarding the consent. I know that we have a gesture, but there's a series of questions and statements made that are never addressed because they're never interpreted for either Detective Kinnery or the sergeant. There's a question that's being asked by my client about the ability to search based on need for a warrant, and Sergeant goes on to say, Sergeant Roberts says, is he acknowledging? But that's never finished because at that point Detective Kinnery is already gone.
What is your best response? So it's not like Judge Locke doesn't address this. I think you need to warrant a search, but Judge Locke addresses this and she says, in my view, that is a very ambiguous statement because on the one hand, it could mean what you're now asserting, which is basically taking back what the person just said. But it also could mean, I think you'd normally need a warrant, but I have nothing to hide, so I'm not going to insist. And Judge Locke says that statement, even if translated, is ambiguous as between those two meanings, and thus would be insufficient to withdraw any consent that was just given.
And Judge, my argument to that is I certainly understand that's one way you can look at it, but I still submit that if my client is inquiring about.
But wait, once you've conceded that it's one way you can look at it, how could it possibly be clearly erroneous for the district court to have looked at it precisely that way?
Because I think when the sergeant asks the question, is he acknowledging, that sergeant is raising an issue whether or not there is consent. I think that statement by Sergeant Roberts is what's most troubling, because there's a dialogue that's not being interpreted. It's a conversation between, unfortunately in this case, between a Spanish-speaking officer and my client who's a native Spanish speaker. There's a question about a search warrant, enough to the point of raising concern for the Sergeant Roberts to ask, is he acknowledging? which goes to Sergeant Roberts, I don't believe is thoroughly convinced that consent has been fully given.
Does that matter? Under the Fourth Amendment, I guess if there's one message I take from the Supreme Court's Fourth Amendment cases is I'm not supposed to ask what an individual officer subjectively believed.
I understand that, Judge, but I think if we're looking at the totality of the circumstances, which is the standard that we need to apply when we're looking at whether or not consent was voluntarily given, this case becomes.
Were you there? Were you involved in the hearing?
Yes, sir, Judge. This was my case in the district court.
That's what I'm, you represented this fellow at the hearing,
Yes, sir, Your Honor.
so you were there as well?
Correct.
Now, okay.
I'm sorry. Yes, sir.
So,
And to be fair and not
I
bury
guess
the
you could
lead,
be a witness too.
well, Judge, not to bury the lead, but
You are, but you're not here as a witness.
I'm
you're
not here as a
lawyer.
witness, sir. And to be fair, I am a native Spanish speaker. It is my first language, so I do acknowledge that when I represent clients, I'm at an advantage with respect to them because we
Yeah,
are
I
speaking the
understand,
same
and I
language.
appreciate that, and I appreciate your work to represent this fellow.
Thank you, Judge.
Be
But
clear
again,
on
and
that. I just
thank-
wanted to know for sure.
Yes, sir.
If you were looking at a cold record like
Yes,
we
sir.
are, or if you were counsel to this fellow all the way through.
No, Judge, Mr. Anthony and I have been with this case since the beginning. But Judge Hyden, to your point.
You were at the hearing, you weren't there at the door or in the house.
I
when all
was
this
not there at the
going
door.
on.
No, sir, Your Honor.
You were at the hearing on the motion to suppress.
I was there one step before. This case originated at the state level on
Okay.
the alleged bomb threat case, mass murder case.
Yeah.
I was retained on that. When those charges were dismissed by the state courts, Mr. Alvarado Dubon was subsequently arrested on federal charges, and the court asked me to accept the appointment because I had done the state charges.
But
So-
you were present at the hearing before Judge Locke.
Yes, sir, Your Honor.
That's all that's
sorry.
what I
Yes,
was
sir.
getting, now I understood, that's what you'd be saying. Want
Yes,
to make
sir.
that clear, though.
Yes, sir. But Judge Hyden, back to your point, I think what my argument is, in order to look at the totality of the circumstances, this is complicated a little bit, in my opinion, and what may make it a clear error is that you have a language barrier that's creating issues to what I believe is a truly consensual search that is alleged to have been granted. That's the argument with respect to the consent. With respect to the protective sweep, Your Honor, my time is running, I'll try to get to that very briefly.
There's no difference between a consent and a truly consent. It's a consent.
Period.
He had to consent.
Regardless,
And
yes.
Judge Locke found he consented.
Judge Locke found he consented. My argument goes to whether or not her decision was a clear error, given the confusion that you see in the transcripts, according to my argument. With respect to the protective sweeps, Your Honor, the officers, they are not there to effectuate an arrest as they did in Maryland versus Bowie, but we know that the courts are moving away from clearing just arrest as a basis for a protective sweep. You can articulate facts. The government talks about all.
Well, they always have to protect themselves.
Yes, sir, no
and
question.
And the public, or if there are possibly other people in a dwelling or a building.
Sure,
you
no
gotta
question,
think
Your
about
Honor.
them too.
Yes,
I
sir.
mean, And
My-
here they had allegations of assault weapons and mass killings and all kinds of things like that. I mean, officers, these officers were dressed up in armored,
Correct.
with chest protectors and all this stuff.
Yes, sir.
They always have to, but particularly in this situation, have to be on the lookout.
Judge, I agree, but
It doesn't make a difference whether they're you said they're executing an arrest. They weren't doing that here.
Judge, I'm starting with the basis established in Maryland versus Bowie, but I'm also acknowledging that there is case law that talks about it's not just whether they are there for an arrest. You can look at the facts surrounding why they are present and see if there are articulable facts that would make it reasonable for an officer to effectuate the sweep that these officers do. My argument against that, Your Honor, is that in this case, the police rely upon a random anonymous tip. They verify an address and a name. When the police arrived that night, they talked to my client, who is not the person who is referred to as El Chapin or Mr. Balcarcel, one and the same person who they believe is the target. My client is there. He says, I live here. My son is not here. Mr. Balcarcel, the person who is the target of this investigation, comes out from the back. They have pictures. All three officers acknowledge that clearly the person in the picture is the person that's standing before them. So at that point, they have.
And he denied it was him.
He denied it was him, but all three officers immediately said, yes, clearly this is the person before us. And
So they had him lying, as far as they were concerned.
yes, sir, Judge, no question. But my argument, so they rely upon that, they have the target of the investigation there. And I believe that at that point, given the fact that there are three officers, you have the two individuals, you have them establishing Mr. Balcarcel, who is the alleged target of this anonymous tip, I think they have the information for them that they need. If they want to look further, I think they can take Mr. Balcarcel into custody, which is never done. He's not taken into custody that night, he's not detained. Once the police leave at that point, they have not taken any action with respect to Mr. Balcarcel. So I'm not really quite sure what the fear of Mr. Balcarcel was. If they knew it was him, they believed it was him wholeheartedly because they had.
So these are arguments that assume you can do a frisk, at least in some circumstance, a sweep in some
Yes, sir,
circumstances,
Judge.
right? Okay. Because are you aware of any court of appeals post-Bowie
Yes,
that
sir.
has actually grappled with Bowie's reasoning that has not said that you can do a protective, sometimes you can do a protective sweep even without an arrest?
Judge, I will concede that the most prevalent case is United States versus Everett, 91 Fed 4th 698, and there's a reference to Laudermill. Both of those all acknowledge.
But of course, saying you can do it isn't saying you can do it here, it's just saying you could do it in
Right,
principle.
all of them have moved away from Bowie saying you need an arrest to be able to do that. That was my point. I'm acknowledging
Yep.
the negative precedent that they're moving away from requiring just an arrest warrant. You as an officer can articulate facts. The question is whether the search on this day was merely a hunch that they would find something else, or whether it was an articulable fact to be able to do the protective sweep. I'm about to run out of time, so I'll stop at this point, Judge. Thank you very much, Your Honors.
You'll save some time.
Thank you, sir.
Mr. Anthony?
Good morning. I'm Stephen Anthony for the United States. May it please the court. When the defendant told Richmond police officers who were allowed in his home without any confrontation that they could go ahead and check, there's no one else here, he clearly, unequivocally, and voluntarily.
Counsel, before you go further into the house, this was just a knock and talk only, correct?
That's the way it started, yes, sir.
Boy, that's the way you get in without, in terms of constitutional protection. He opened the door and knocked to talk, right?
Yes, sir.
Okay, so, but then they went straight away to look for somebody almost, didn't they?
No, sir.
Oh, they didn't? Okay. Well, tell me the conversation they had with the talk with the person who allowed them in for that scope of their being allowed to come in.
Yes, sir. So the three officers enter what I would call the living room area of the house, and there is the defendant and another individual who goes by the name of Balcarcel at the rear of the living room. And what the officers start to discuss with the defendant is, do you know the person in a photograph? I believe they have it on their phone initially. They show him the picture. He initially says, I can't see it, let me see it again. They show it to him a second time, and he says, I don't know that person.
All right.
They then take the phone over to Mr. Balcarcel, and they say, do you know who this person is? And he denies knowing who that person is.
He said no.
That's correct.
Okay.
And then.
So that's the talk. Okay, what
Yeah.
else after that? They both
After-
said they don't know the person that's been shown on the picture. Go ahead.
Yes, sir. I believe it was Officer Kennery showing the photo. Officer Kennery then goes back over to Officer Ferreras and shows the picture again. And I believe it's Officer Ferreras who says, well, that's him, pointing to Mr. Balcarcel. And he says, yeah, it's the same beard line and everything. And they take the picture back over and they say, that's not you? And I don't recall if Mr. Balcarcel either says nothing or denies again. But at that point, the officers had denials from both the defendant and the suspect that the individual in the photo, who was Mr. Balcarcel, was not him. So that was the talking portion initially of the knock and talk. After that, Officer Kennery asked Officer Ferreras to ask the defendant, are there any weapons in the house? And I believe, is there anyone else here? And that's when.
Well, in America, you know, that's no problem, right? The Constitution, you know, it's brewing in all these cases. That's a typical American right and tradition, isn't it? Having a gun, I mean, that's constitutionally protected.
It would be constitutionally protected.
Not
yes, sir.
contraband, and it doesn't come with any kind of implications at all about illegal, does it? That's how it works for everybody else. That's how it works for everybody else. Matter of fact, you can carry it around,
Sure.
right? Okay, but go ahead.
Not in and of itself is the possession of a firearm illegal, no, sir.
Sure, certainly.
But at that point, the officer is coming to the home on the information that someone in that home possesses large caliber rifles, has made a threat.
Yeah, but now aren't you changing the scope now? This is to knock and talk. You've asked the question, they've answered it. So now you're saying because for what you know, then it's almost it's a planned search almost, isn't it?
No, sir.
Well, the talking is over.
No, talking is continuing.
But he could have stopped you, because he could have thrown you out, not thrown you out, but said, get out of my home.
I think up until the point that the officers determined that there is a rifle in the house that matches the description, the defendant certainly could have withdrawn consent or at least attempted to. That did not happen here. What happens is the officers come into the residence, again, on the information of a tip about potentially a mass shooting. As they enter the home, they see indicia of firearms possession, namely a handgun magazine, I believe a rifle round on the mantle right near the front door. They have the fact that the defendant and the suspect, Mr. Balcarcel, have denied knowing that it is him in the photo. And so at that point, the officers are suspicious that there might be someone else in the home that could cause them harm. And so Officer Kennery says, tell him that we're going to look around to see if there's anyone else in the home. And that's when the defendant says, go ahead and check, there's no one else here. And only after he says that does Officer Kennery then begin to go toward the rear of the home to see if there was anyone else.
So what was said to him was not a question, but it was telling him that's a direct, we're going to do this. We're going to do this, right? Didn't ask, may we? It said, tell him we're going to do this. Is that right?
It was a statement, yes, sir.
Right. And then how many people there? They were armed police officers, right?
There are 3 armed police officers.
Right.
yes, sir.
And they told him, we're going to do this. And you say that the consent arose from that statement, directed.
The consent arose from the statement of, we're going to check to see if there's anyone else here. Yes, sir.
Do you really think he had a real opportunity to consent or to not give it?
Yes, sir.
3 police officers, they're armed with like SWAT team type, right?
I don't know if they're armed like SWAT. They
Well,
do
in
have-
SWAT, I mean, they had bodyguards, you know, the police on the back and the big writing and their weapons, right?
Yes, sir.
And they said, that's what we're going to do. And you think that that was consent?
Well, I think a couple things. First of all, the district court found that, and I don't think there's any evidence that is clearly erroneous, but beyond that, what the district court found is that the tone of the officers, the behavior of the officers, despite having weapons, nothing they did indicated a show of force. They never displayed their weapons in any way. It was simply a conversation they were having up until the point that they decided to make a walk around the house for other persons. So there was nothing in that.
It wasn't a search, it was protective sweep is what was called, right?
Yes, sir. I'm sorry if I said search. Yes, it was a protective sweep because they were looking for individuals that may have been in the home that could cause them harm while they were lawfully present in the home. And so again, when the
So you're
defendant,
only looking for human beings in the home?
that's correct.
Okay, so you wouldn't go into any drawers or cabinets or anything like that?
That's correct. And I do believe the officers could have gone into a closet potentially because a closet. could
How
be
long
large.
does protective sweep take?
It takes the amount of time reasonably necessary to dispel the
No, but
suspicion.
this one,
Oh, this one was about 15 seconds.
15 seconds?
Yes, sir.
And that the record reflects that?
Yes, sir.
Did the judge say that?
Judge Locke did find that it was about a
Okay.
15-second look around the residence. And then in plain view, as the officer is going through one of the bedrooms, he sees what appears to be the same rifle about which they had received the tip.
The same rifle or the
yes.
same type?
Well, same type of rifle, I should say.
That had been described by the tipster?
It had, and it had been described specifically
That
as
was
having,
a, what, an AK-47 or a AR-15 or
I
something?
believe it was described as an AR-15 type rifle.
AR-15 type?
Yes, but more.
They're
spec-
legal, aren't they?
They are legal.
Right, that's what, again, they're legal. I mean, you have it both ways. I mean, Supreme Court said those things are legal.
Well,
Because people need them to protect themselves.
Sure. It could be legal in one context,
Because I
but,
guess, oh, go ahead.
but I think the point is what they were looking for is not something of an illegal nature necessarily.
Why
What
didn't you
they're-
get a warrant then?
Well, they're legal in some states. We've said that Maryland can make them illegal if they want to, and they have.
Yes, sir.
Why didn't you get a warrant if you had all these tipsters and then, and just search the house that you normally would, and you have a chance for an independent magistrate to say whether or not this supposed, this sweep, you had good grounds, right? To say that it's likelihood, and based on what we've been told by these, people, whoever the informants were, the tipsters were, that there's contraband and/or individuals who are suspects, and you've gotten a warrant. I mean, that's what the Fourth Amendment is for. But instead, you come in and you say to a person whose English is not their, I guess, their native tongue, and then you tell them, this is what we're going to do, and then it's a protective sweep. Protective sweep, really, you don't really, never mind, go ahead.
Well, I'll speak to your question, Judge. There may have been an opportunity to gain a search warrant at that point. However, there was the point of clarifying and confirming that the suspect did live there. And so that was the purpose of going for a knock and talk to see if they could identify the suspect there. And they did identify the suspect
Why
there.
didn't you arrest it right there while you're standing there with you?
Well, at that point, they had a suspicion that he may have made the threat and that he may have possessed a firearm. They hadn't confirmed any of that yet. So the point was to get confirmation that the suspect lived there, A, and then do further investigation to show, A, or B, that he may have made the threat, and C, that he also possessed the capacity, that is, the firearms that he was alleged to have possessed. And so what the officers did, I think, is the least intrusive method they could have used, which was not to get a search warrant and then also arrest the defendant or arrest the suspect without making those other preliminary investigatory steps to confirm that they had a basis to do that under the law.
This was all an investigation,
Yes, sir. It might even be,
and there was no search conducted. That's the position of the government.
that's correct. And actually, after the first firearm is seen in plain view, they didn't go through searching the house by themselves at that point. Actually, the defendant came to the bedroom and then started to show them where other firearms were and actually showed him where his identification documents.
Wait, do you think a search done with consent is not a search, or do you think a search done with consent is categorically reasonable under the Fourth Amendment?
I would say it's both, but that wasn't what happened here. The consent was to go.
Well, but how is not going into the other room a search? I mean, it may be reasonable. It may be reasonable because the defendant consented. It may be reasonable because it was a valid protective sweep, but does that change that it's a search?
Yes, sir. I believe a protective sweep would be different from a search. In
Wait,
this-
hold on. But the Fourth Amendment only regulates searches, and we agree that the Fourth Amendment regulates protective sweeps. So if the Fourth Amendment regulates protective sweeps, then protective sweeps have to be searches. I agree they're not arrests. I agree they're limited searches, but I don't know what authority says they're not searches under the Fourth Amendment.
Well, and that may be a question of my own semantics in trying to distinguish.
Sure, it's not a full-blown search. I know, it's not a custodial arrest. It's not there's no,
I
there's-
don't want to confuse it with either some sort of need for probable cause.
Totally.
Or actually a more intrusive actual search where they are going through drawers or pulling apart furniture or something like that.
And I may have led you into that.
I think you expressed your view and how you feel about it. But the thing is, if the police officers knock on my front door,
Yes, sir.
and I open the door, and they see someone moving behind me in my home,
Yes, sir.
they can say, I feel like I need to be protected, I can go and sweep for my protection. That's basically what you're saying, because it's not a search anyway, you say it's just my protection. And I can see a police officer might feel like, I'm at the door, I'm in the threshold right here, and I see somebody go that way. But that's my home. I could have 50 people, 20 people in there, I guess, in my home. All of a sudden now, because you need to be protected, you can just walk in and say, because of my protection, that was the whole purpose, because the person you were looking for, the man said, well, that's him right there. He's there, you're finished. So, but you said you can go through the house because you feel you need protection. And that's the hypothetical. You could go through my house because you saw someone walking across behind me into another room. So who's that went, I feel threatened. I'm going to go in and check on them and see if they have a gun or whatever. In that hypothetical, that's not a search, and you could just do that. Is that right?
No, sir.
Okay, what's the limitation there then?
So the limitation in doing a protective sweep is the same as the limitation you would have in a Terry stop, the same as you would have in a Michigan versus Long situation. The officer has to articulate specific facts which lead him to be concerned that someone in that residence poses a threat to him, and therefore he needs to make sure that there's no one else in that residence. What we're talking about is not just an officer, because he's in the home, gets to check it out to see who is there, or the absence of information. In fact, I believe one of the, this court's cases, if not Everett, it was in Portis, specifically said the lack of information doesn't provide a basis to do a protective sweep. What we have to do is articulate facts to show that there is some risk to the officer, and then along the lines of Terry and Long, an officer can then do a protective sweep, a very cursory, short in time protective sweep to confirm that there is no one else present in the home that might pose a threat to him. So in your hypothetical, Judge, simply the officers being there without any other information about why the officer's there, whether you would in fact even be a suspect. They could be knocking on your door as a witness. And certainly they wouldn't have any reason to believe at that point that there was somebody else in the home, or not necessarily having a reason at that point to believe someone else in the home would pose a threat to them. They would not be able to then just go through your house in that circumstance. In this circumstance, what we were talking about is a set of officers with the information about a armed person making threats, having long rifles, or long guns rather, one being a style of rifle that we know does cause mass damage. And then when they get to the home and they're led inside, they actually see indicia of the presence of firearms, the handgun magazine, the rifle round. They also are aware at that point that other people live there besides the two individuals they're talking to. One of the first things they converse with the defendant about is that he has two other sons who live there. Now, he also says they aren't there at the moment, but again, we have the fact that the officer's showing him a picture of the suspect, and the defendant both denying it and the suspect himself denying that that's him when it is indeed him. So all of that information taken together is what the district
So
court.
the suspect was lying.
Yes, sir.
So you think the difference here, the tipster makes a big difference here, right?
I think all of these facts makes a difference, and it's a conglomeration of them on which the district court.
How does the tipster matter for the consent issue?
Well, the tipster matters in terms of the protective sweep.
Sure,
issue.
but for the consent issue, it doesn't matter at all, right?
No, I don't think that
Okay.
the consent issue mattered, but only in the sense that that's why they were there.
But the Fourth Amendment, your friend has conceded that that until that happens,
Yes, sir.
nothing that happened implicated the Fourth Amendment at all.
Yes, sir. I don't think there's any dispute about the officers coming into the home being a matter of consent. There was no mistranslation there. He was clearly able to understand Officer Ferreras. Indeed, there were moments when the defendant was able to understand Detective Kennery speaking in English. I'll give you an example. When Detective Kennery goes and sees what he thinks is the rifle, he says, "I got the rifle in the room." The defendant responds directly to Detective Kennery and says, "No, it's an air rifle." And then Officer Ferreras tries to translate it, but he's like, "No, it's an air rifle, I can show you." And so he goes back to the room with Officer Kennery, and that's where the other firearms are found. So there's no mistranslation from the United States perspective in Spanish, and there's even some understanding of English by this defendant, which also goes to the issue that there's no lack of consent, certainly no withdrawal of consent, the district court found clearly and unerroneously that this defendant consented. Just to say a little bit more about the protective sweep issue and why this court should extend it from the arrest context to non-arrest context. Again, the logic behind Maryland versus Bowie, the United States believes, is that the officers have a right to protect themselves when they have a reason or they can state reasonable articulable facts that there might be someone else in the home that could cause threat to them. And that is not dependent upon whether they are there to execute arrest, conduct or serve a protective order, or on the basis of consent. If they are in that presence of, or in the presence of a residence, and they have a basis to believe, and they can articulate that there might be someone else who can cause a threat to them, the protective sweep would allow them to do that. A cursory, shortened time protective sweep that is not as intrusive as any other search, as Judge Heitens was mentioning, that the Fourth Amendment would prohibit.
And that would include children too, right? Any person potentially could be a threat to you, right? Children?
I mean, certainly not an infant, I don't think, but.
No, I said children, I didn't say infant, but children, like 6-year-olds, 7-year-olds, right?
I wouldn't want to put a particular limit based on age.
You're right, because there is no limit in terms of what you're urging the court to do. In other words, once you said anyone who could potentially cause harm to them, I mean, that's pretty much from about, 5 or 6 years old up.
Well, I think there's a logical limit that we could impose. I know the court says you're talking about children, not infants, but I would argue infants fall under the category of children. But some 6-year-olds have more dexterity and capacity than other 6-year-olds.
Well,
I don't know what sort of situation.
I think most 6-year-olds could shoot a handgun, just pull the trigger.
If that's the case, then, Judge, I believe the officers would have the capacity to at least look to see if that person was there, and see.
And it might be, if the kid comes around, or if somebody comes around, there's more danger in terms of someone getting killed. I mean, otherwise, you do this protective sweep, the broader you get it, the more likely in terms of engaging people in homes. I mean, I guess, certain homes they come to, maybe they're more limited. Other homes, they feel more danger, right? And that's the problem in terms of that subjective idea. It comes with demographics, the neighborhoods you're in and everything. The sweep gets larger, smaller based on what your perception is, the demographics, the neighborhood, income level. It comes some homes, like a mansion, you don't go anywhere at all. Other people have 2-room places. We need to make sure there's nobody in here. That's the limiting aspect of it. From a tipster, that no independent magistrate ever assessed reliability, where they were and who's calling. Was this a tip from somebody who didn't? We don't know in the record who that was. For example, a next door neighbor could say, I believe my neighbor is doing something, and they have guns. So when you knock on the door, then you feel, as here, any movement like that might be a threat because the tip included having a gun, right? Don't you agree with that, based on your logic of where you're going, that increases the concern of protection based on what the tips are said, like here, because there were guns implicated, and I understand that, but what's the limiting aspect of it? The Fourth Amendment it's very difficult to see why I thought one of the most powerful thing that the framers did, and they said about government, they were suspicious about government. No, you can't come into my house and search without probable cause. No, you can't. They were defiant, but now it's almost like, well, it's sweep, how broad it is. So what's the limitation?
I see I'm out of time. May I respond?
You absolutely.
Thank you.
As long as you get questions, you keep answering.
Yes, sir. And Judge, there was a number of things you mentioned. I want to try to address as many as I can in my allotted time. First of all, I would say that it's not a subjective measure of what an officer feels and whether he just feels threatened. Again, he must articulate a reasonable basis for.
High crime area, that's articulated.
I'm sorry?
It's a high crime area. They do it all the time. High crime area. That's it, period. That's enough. Normally it is. I mean, I've had a lot of cases, that's what they said, high crime area,
Well, I would just say.
high unemployment, whatever.
I would just say that the officer is not able to rely solely on subjective basis to do a protective sweep. Secondly, in terms of whether the tip matters ultimately for protective sweep purposes, certainly it does. I would also note that this wasn't merely a anonymous tip. The record shows, and I believe it as Joint Appendix page 52, the testimony of Sergeant Rogers, is that one of the officers actually called the tipster and spoke to him directly and discussed both the description of the suspect and the threat that the tipster had alleged that he had made. So it wasn't merely an anonymous tip. And the officers did other research beyond that before even going to the residence. They spoke to the suspect's boss to confirm both where he thought he stayed, his identity, that he potentially had connections to Los Zetas was a Mexican cartel. They also checked the calls for service in the area, and they saw that maybe 10 days before.
So you had
I
plenty of
believe,
opportunity to get a warrant for his arrest.
they had an opportunity to conduct an investigation.
You had plenty of opportunity to get a warrant. What you just articulated there, I don't think a magistrate would have any problem giving you a warrant.
And again, the point of them going to the house was to use the least intrusive means that they could use, which at that point was a knock and talk to confirm that the defendant was there, or the suspect was there. And so I don't think the officer should be held at fault for being least intrusive when they could have been more intrusive. In
That's
this
not the
case-
least intrusive, more intrusive to come to my home without a warrant.
Well, it's least intrusive because they were there by way of consent. And so you search warrant, you don't have any consent, they might kick the door in. So that's more intrusive than asking, can we come in and speak? And you say, yes, come in.
Richmond police wouldn't do that. I know them very well. They would knock on the door as ladies and gentlemen and say, somebody here, and they wouldn't kick your door in.
I would hope they would, Judge, in
I'm
those situations.
sure they wouldn't. I practiced law in Richmond for a long time, criminal defense work, and I don't think the Richmond's finest, as they call them, would just do that.
Well, I won't comment on that, Judge. I would just say
All
that
right.
it's the least intrusive from my
Okay.
perspective. If there's nothing else, then I would,
Thank you very much, Mr. Anthony.
thank you.
We appreciate you. Mr. Aponte?
May it please the court again, Your Honors. We talk about the least intrusive. I think that's a fair point. Yes, my client was cooperative to the extent he allows the officers to come into his home. They're engaging in a conversation. As was asked, the
He
officer.
wasn't cooperative if he was lying to the officers.
Judge, the line was, he was shown a picture on a phone. He said, do you recognize this? He's first asked, do you recognize the name El Chapin? Is what he's asked. Like, I don't know who that is. He said, I don't know anybody by that name. Then they show him a picture, do you recognize this guy? He says he has a hard time seeing it. Mind you, we're close to midnight. He's woken out of a dead sleep. He's got 3 armed officers in his living room. I think he's still coming to his senses when he's, phone is put up to his face. I mean, it takes me a while to put on my glasses to be able to be coherent and see articulately, or see clearly, if you will. Judge, when they come in, the defendant is cooperative. The person who they ultimately believe is this person is the other person that comes out of the back of the house.
The person that they ultimately believe, or the person that we've ultimately determined was in fact?
Well, the person, they come in saying, we're looking for Balcarcel. We have this picture. The officers, all 3 of them, throughout their testimony, said we had no question that was him. If that's the case, detain Mr. Balcarcel. I know you may not have enough to arrest. You have enough to detain him. You have enough to ask questions. You have enough to freeze the scene and go get a search warrant. But there was no intention. The intention was to go find what they believe was the fruits of this crime. That was Kinnery's intention when he didn't ask if he could go look. When he didn't specifically ask for consent, he said, tell them we're gonna go look. That was a directive. That was not a request. That was not a asking for consent. That was, here's what we're doing. And I think during the course of that interaction between the Spanish-speaking officers and Sergeant Roberts, there's a question as to whether or not he could do that, or whether consent had been unequivocally provided by Mr. Alvarado Dubon to the police officers to go back into the rest of the house.
Didn't they also, to your client, ask him if he knew, if he recognized the name, the first name. He didn't just say El Chapin, right? He gave the first name of the person they were looking for.
He gave the name El Chapin, and the second name that's given, I think, was just the last name. I don't think they.
Well, we gave a name. It wasn't
Yes.
just a sort of nickname.
Sure.
And your
I-
client also said, I have no idea who that is.
But again, Judge, these are people who are, he's there, we don't know what my client knows, but yes, he denies knowing the name of the person as Bal Carcel. But then going back to the protective sweep, Judge, at this point, the officer has had the ability to detain Mr. Bal Carcel, who they believe is this mass terrorist, which they don't. They have Mr. Alvarado de Bond, the homeowner. They can detain them, they can get a search warrant, they can freeze the scene. If they're gonna freeze the scene to get a search warrant, I think they can make sure nobody else is there, but they don't freeze the scene. They immediately go to look for what they believe, because Kinnery says, hey, I found it. Yes, you found an air rifle. That's what you found, Detective Kinnery. You didn't find a weapon of mass destruction, you found an air rifle. And then that's where everything else flows from. And I submit to the court that Detective Kinnery steamrolled through this quote-unquote consent, got to the back rooms by using the idea of protective sweep when there were other lawful methods which could have been used to achieve the same result. Thank you, Your Honors.
Thank you very much, Mr. Aponte. And we recognize that you're appointed in this case.
Yes, sir.
We really appreciate your work and what you do. Thank you. We'll come down and greet counsel and then take a short break.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
You may be seated. Our final case today, United States versus Ordonez and others. Mr. Berman?
Good morning, Your Honor. May it please the court, I'm Stuart Berman, appointed by the court to represent Jose Domingo Ordonez Zumeda. I'd like to use my time here to address the interstate commerce issue. Now, this court has been hearing MS-13 conspiracy cases for 15, going on 20 years. And those cases usually involve a pretty sprawling range of conduct. Here we're at the opposite end of the spectrum. We have a single homicide in Prince George's County, events that really took place over just 2 days in 2019.
Can I ask you to zero in on what I think is the biggest problem for you? You seem to assume that the crime has to affect interstate commerce, but doesn't the statute say the enterprise has to affect interstate commerce?
Agreed, Your Honor.
And how, do you agree with me, there's testimony that members of this enterprise send money outside the country?
Well, Your Honor.
No, that's a factual question. That's a yes or no. Is there evidence that members of this enterprise routinely send money outside the country?
There is testimony from Mr. Martinez Ramirez, also known as Killer, who testified in a very vague way that money was sent to El Salvador to help prisoners and also to buy weapons.
Okay, so why is that not just ballgame? Because
Well,
I assume the jury believes that testimony, which means that members of this enterprise send money to El Salvador as part of the enterprise. And now it seems very obvious to me this enterprise affects interstate commerce.
Well, Your Honor, what I would submit here is that we don't have any dates, we don't have any times, we don't have any amounts, we don't have any details.
Why does any of that matter if the question is whether the enterprise affects commerce?
Well, even under this court's de minimis test, I would submit that we need something more than this very vague testimony that at some uncertain time, in some uncertain place, and in some uncertain amount, that some kind of unknown amount of money was sent.
These all strike me as great questions that could have been asked in cross-examination.
Well, Your Honor, I would submit that the government, to meet the de minimis test, was required to prove something more, was required to show some kind of documentation from the bank or from Western Union or El Salvador, which has adopted cryptocurrency, some evidence from a crypto platform. And of course, there's no testimony that any of this money had anything to do with any racketeering activities by either the...
It doesn't matter. It matters whether the enterprise affects commerce.
Well, I understand the court's point. I just think that there are real limitations.
Wait, hold on. But the testimony at JA 907 is, did you pay any money to be in the clique? Yes. What? At first $200, then later $100 a month. And who did you pay that money to? It was given to the leaders. What was the money for? The money was sent to El Salvador to help prisoners and also buy weapons. Why isn't that testimony that this enterprise affects commerce?
Look, Your Honor, I understand the point, and I understand the limitations of the de minimis standard, and I understand I'm here on a sufficient...
So $100 a month is de minimis? $100 a month is de minimis?
Well, again, Your Honor, I suggest that something more was needed in order to fully establish the interstate commerce aspect under Morrison, to show that this homicide was somehow directed at the instrumentalities and channels and goods. And I understand Your Honor's point that we're focusing on the enterprise as opposed to the specific offense. What I would submit more broadly, Your Honor, is that most of these MS-13 racketeering cases, most recently Baronet, there's usually a combination of factors. For example, in Baronet, there are guns from manufactured outside of Maryland, drugs that came from outside of Maryland, extensive use of phones. And here the government attempts to present a similar sort of combination platter, but I think that it simply doesn't work. Not just the money, but the marijuana. The only evidence about the marijuana was that one person sold some unknown quantity of marijuana in New Jersey, and the government didn't establish it. There was an interstate character to that. The call to Penguino, we have no testimony about who Penguino truly was or that he even exists. No phone records to corroborate that call, even though the government presented an extensive cell phone analysis from Special Agent DeJesus. The government introduced evidence that they didn't rely on a trial, but rely on here about Uber, and I submit that evidence simply proves that Uber operates in interstate commerce, not that this clique did. And finally, the government at trial, but to its credit, not in its brief, references the movement of the corpse from Maryland to Virginia. I would submit that a corpse was not a good, and Congress has recognized itself, and the courts interpreting the kidnapping statute have recognized it in the vast panoply of things over which Congress has chosen to exercise federal jurisdiction. Corpses are not one of them. So I would submit that collectively, I would submit that individually, none of these little fragments on its own proves interstate commerce, and I would submit that collectively they don't either, and that the court should reverse on counts 1 through 3 for failure to meet that element. Thank you.
So throw out those 3 counts, that's what you want us to do.
Those 3 counts, Your Honor, I think the government correctly points out in its brief that count 4 doesn't have an interstate commerce element, wouldn't be affected by that argument.
All right, thank you very much, Mr. Berman. Mr. Orenberg?
Good morning, Your Honors.
Good to have you here, sir.
Alan Orenberg on behalf of Jose Ortega Ayala. On behalf of Mr. Ayala, I am challenging the district court's decisions to suppress the evidence at the motions stage, because the 3 search warrants that, as I have laid out in my briefs, were so lacking in indicia of probable cause as to render it unbelievable that you could find the existence of probable cause in these cases. In the first 2 search warrants for the Facebook accounts of my client, the officer merely relied upon I guess call it the tip, if you will, of a witness, and then was somehow led to a profile picture, and then in turn got to the Facebook page. In our view, that's not enough, and the district court made a mistake and was clearly erroneous when it said that that was enough. I don't believe that this court, and then once that happened, of course, the search was overly broad, and they went, and the officers asked for a search warrant that spanned some 14, 15 months, not just for the month of March 2019, or perhaps just a month or 2 before March of 2019. This should lead this court to conclude that this was some sort of open-ended warrant, and that this is not allowable, as I've laid out in my briefs in the case law, and that the district court made a mistake when it said that the search warrants for the Facebook accounts should be suppressed. Now, the motion to suppress the search of the residence was based on a slightly different basis. This is, again, starts with the officer getting some information and goes to Uber and sends a search warrant to Uber to get the records of some sort of transportation that allegedly my client made in March of 2019, and then based on that, they go to the home and they find my client. Well, again, there was nothing in that warrant that clearly should have led the district court to conclude that there was evidence of crime to be found in that particular place. I mean, again, the district court erroneously relied upon the warrant to, or granted the warrant and erroneously relied upon the facts that supported that warrant.
Didn't the warrant say that he took the Uber home after the murder?
Yes, that's what the
Why
record
isn't it
revealed.
almost obvious beyond belief to imagine that a place that a person went right after a really violent murder might have evidence relating to that murder?
Well, first of all, he didn't take it from the murder scene. He took it from another home.
Okay.
He went with others to another place, and from that home.
Okay, but it doesn't really feel like a far stretch that when a person goes home after having been involved in a violent murder, that there might be evidence in their home of that murder.
Well, Your Honor, there was nothing in the record that showed that there would have been.
Clothes, the things he was wearing, hypothetically say?
All they said was that the Uber records show that he moved from position A to position B. It did not specify with particularity that we believe that there are instrumentalities of the crime. The court doesn't have any more questions.
Did you try the case?
No, I didn't, Your Honor.
We appreciate your work.
Thank you, Your Honor.
Mr. Byrne? Good to see you, Mr. Byrne.
Good to be back, Your Honor. May it please the court, my name is Jonathan Byrne. I'm here this morning on behalf of Jose Henry Hernandez Garcia, one of the defendants below. Question, did someone tell you to change the time in your final report? Answer, yes, sir. Question, who told you? Answer, it was someone from the investigative team. They said to narrow down the time. Presented with a new trial motion based on a government witness's testimony that he changed an expert report at the behest of other investigators to bolster their case, the district court abused its discretion by not weighing in on its own on the credibility of the government's witnesses and its case, sitting as a 13th juror, as this court has required. This
What is
court
your, I'm a little confused about your argument. You agree with me that the district court recited the correct legal standard, right?
Yes.
And your argument is essentially that the district court was, and you agree the district court, having recited the legal standard, denied the motion, right?
Correct.
And your challenge, I read your challenge basically as to the fact that the district court did not explain why it was denying the motion. But I was on a case like this a while back, but I also looked through your brief. I don't see any cases saying district courts have to explain why they're denying the motion. Do you know any case that says that?
I'm not aware of a case specifically, Your Honor, but there is some explanation in this case, but the explanation is the jury was aware of all this, therefore
Right,
I'm
that's
not
an
going to
explanation
say.
to deny a Rule 29 motion.
Well, that's my point.
Right, but the district court, so why don't I just interpret what the district court said is, I'm denying the Rule 29 motion for this reason. I then, on the Rule 33 motion, I state the correct legal standard, say motion denied. And then it seems to me you just have to identify some legal basis for the proposition the district court has to explain its reasoning. And I'm not aware of any case, I'm not aware of any provision of the Federal Rules of Criminal Procedure that requires the district court to explain its reasons for denying a Rule 33 motion.
Your Honor, I believe when the district court made its ruling that it did state with specificity on the Rule 33 motion that it was, that argument had been presented to the jury and it was going to defer to the jury's finding. I don't think that was just on the Rule 29. And that's the error here, because Rafikian was very clear that Rule 29 and Rule 33, they're different standards. And it's an important distinction in this case because the government's case against my client basically rose and fell on two witnesses who were perpetrators of this offense who cut deals to testify at trial. And they were, to their credit, pretty upfront that they were testifying to make
But
life
credibility
easier.
issues are for the jury normally.
Yes, Your Honor, and under Rule 29, the district court or the defendant is stuck with the district court reviewing that in the light most favorable to the government. But under Rule 33, Rafikian says the district court sits as a 13th juror on new trial motions. And so when the new trial motion is the government's case rises and falls on these two witnesses, the only corroboration is this report prepared by the FBI agent, Agent Jesus, in which he admitted, I changed the report because the investigative team said we needed to narrow that timeline. I mean, that is a government witness saying, I changed the report to make our case better. And that should raise alarm bells about the nature of the government's case. And so these two witnesses, as I said, were very upfront that they were trying to get themselves out of this in the best way they could. They admitted that they lied repeatedly in their statements about this case. One of them, Mr. Martinez Ramirez, said, I was trying to help myself. Changing my story, I was trying to help myself. And so the district court, in ruling on the Rule 33 motion, should have dove back into that and done more than this was presented to the jury, and I'm going to leave it with that.
Were you involved in the trial?
No, Your Honor.
We
Sir.
appreciate your work, but you've got some rebuttal time
Thank you.
saved.
Yes, sir. Thank you.
Thank you. Mr. Rodker?
Good morning, Your Honors, and may it please the Court. Michael
see you.
Rocker from the Department of Justice on behalf of the United States. I think what I'll do is just address the issues in reverse order. So I'll start with the issue about the new trial motion then we'll get to the warrants, and then I'll conclude with the sufficiency, but I'm, of
You
course,
do it
happy-
however you prefer.
Thank you, Your Honor. On the issue of the new trial motion, let me say, the question about altering the report, it was fully disclosed at trial. It is not uncommon for experts to prepare draft reports that have maybe more data or that go beyond the relevant time frame. So there was nothing below board here. Everything was fully disclosed to the defense. The removal of the data point in question was the subject of cross-examination of the expert, and in fact, in closing argument, the defense counsel, not Mr. Byrne, but the trial counsel, specifically said that that omitted data point should be considered because it gives him an alibi for the crime. The jury heard all of that, and the jury decided to convict. And the question on appeal now is whether the district court somehow mangled it when it denied the new trial motion. But it didn't, Your Honor. This whole idea about having to reweigh the evidence, first of all, the defense in their new trial motion didn't ask for a reweighing. The court's cases don't mandate that a district court reweigh. And as far as the adequacy of the explanation, Judge Heitens, as you pointed out, the district court did say, it was simply an oral ruling that was right before the sentencing. It said, Mr. Walsh-Little, you raise a good point. You raised it in front of the jury with respect to whether some of the cell site information placing your client's phone at the scene is reliable or not. But the jury heard it, and I just don't see how that alone can justify a Rule 33 new trial motion, so I'm going to deny that motion by the ECF.
And so when you
member.
say, you're interpreting, when the district judge says that alone,
Right.
in your view, what the district court is saying, how this point, what the
Yes.
district court just called a good point alone is not
Yes.
enough? Okay.
Yes. And again, it's an abuse of discretion standard. And I would just also say, a lot of times the court, district courts and this court as well, will see new trial motions that are based on new evidence. We don't have any new evidence here that would even require any sort of reweighing.
Oh, I thought you were going to say this court frequently sees rulings on Rule 33 motions that consist of denied.
Yes,
Nothing else.
I'm sure it does. But again, as far as the question about whether some reweighing was mandatory, if you have new evidence, perhaps I could see that
Did you
there's
try the
more.
case? Did you try the case?
I did not, Your Honor. I'm
We
appellate
don't have
counsel.
anybody here who tried the case.
No, we're all new.
You're in the-
Just
you
like
guys
the-
are- You guys are in the same box we're in.
Just like the court, we're all relying on a cold record. If the court has no further questions about the new trial motion, let me work.
You can go however you want to do it.
Let me turn to the question raised about the adequacy of the warrants. I have three basic comments. The first one, I think.
Which ward are you talking about? All of them? or-
All three of them, because
All
my
of them,
argument
all
applies
right.
to all three. First of all, Your Honors, Mr. Ortega Ayala, as far as we're aware, he has not identified any evidence that was seized as a result of these warrants that was then introduced against him at trial. So there's, even if you agreed that the warrants were defective, and even if you found that there was no good faith, I don't see what he's asking to be suppressed. So for that reason alone, I just don't think that there's any kind of issue there. He may want to dispute the warrants. It might be a nice academic question, but in terms of this case, I just don't see, he hasn't identified, and we're not aware of any evidence that was uncovered during those searches that was then admitted against him. And so for those,
Is that argument in your brief?
yes.
Okay. I may have missed it. There's a lot of moving parts in these cases, and I might have just missed it.
I believe it's in the brief,
Okay.
Your Honor. I
Fair
should
enough.
qualify that. I
We're
believe it
all
is.
trying, yes.
But if it's not, I would still say that again, it's a deferential standard
You
that
did
this
write
court.
the brief.
I did write the brief, so I'm responsible for
Yeah,
that.
and the record, and you did a good job with the brief.
Well, thank you,
And-
Your Honor.
And to, maybe to help, just to say that this is a murder case relating to M13 or
Yes.
whatever it's called, from down in Central America, but we got a bunch of students back here.
Oh,
And so they know what is going on a little bit, but no, I'm just mentioning that.
it's a murder case
So
involving
that-
MS-13 and
So that we'll put it in context for them.
Yes,
Yeah.
certainly.
And you're the lawyer from the Justice Department that are defending the government's prosecution and saying the guilty verdicts and the sentences should be sustained.
Thank you, Your Honor. That's a very apt summary. But as Your Honor pointed out, I was not the trial counsel. Again, so at a minimum, Your Honor, our defense is that the
I
district.
wasn't pointing that out, I wanted to know it for my own information.
Understood. Our bottom line, though, is again, the good faith exception would apply. And again, if you look at the record here, you'll see that the district court identified a number of reasons. Your Honor, Judge Heitens, you pointed to one with respect to why it might be reasonable to believe there was evidence of the murder at his home. The district court adopted similar analyses. So we don't think there's any basis for suppression, certainly no basis for throwing anything out.
Can I ask you about the thing that troubles me most in this case?
Please do.
It's a law enforcement officer telling someone who's
Yeah.
being interrogated that it's going to look real bad if you don't talk to me. Can we at first, I mean, you agree this is in your brief, but can we agree, I guess, in open court on the record, that is a really bad thing and you should not under any circumstances do that?
Yes, and I would even go a step further and say that I think Your Honor understated what the officer told him. It wasn't just I don't, how you characterize it, but I think he basically told him, I can comment on your silence.
Yes.
And
Legally
that is
incorrect, totally inappropriate.
Totally inappropriate, not defending it at all. I agree with you, that it was improper, it should not have been done. However, the question then becomes, how do you factor that into the voluntariness calculus? Our position is,
And the reason for that, just to make sure this person was Mirandized,
yes,
and there's no question about the validity of the Miranda waiver.
not on appeal. There was below.
Right, but for us, we're
As
just.
it comes
here-
to this court, there's no question the Miranda waiver is valid.
Okay.
So then as we pointed out in our brief, it's exceedingly rare for there to be a situation where you have a valid and informed Miranda waiver, but statements nonetheless are deemed involuntary. As Your Honor pointed out, and as we have conceded, there is a negative fact in this record in terms of what was told. But the Supreme Court has said that even misrepresentations by themselves and without more, there's no per se rule that they categorically render a subsequent statement involuntary. The district court applied the totality of the circumstances. It looked at all the facts in the record, and it found on balance. It said, I believe the words the court used were that the misstatement about the Miranda warning was not a good fact for the United States, but nonetheless, it said on balance, it doesn't outweigh the other factors.
Is that a misstatement? Is that's,
Well, I know that the court says, there's plenty of precedent that says, so they can lie to you. Police have said, well, you know, we had 5 people that said they
Right.
saw you do this. And of course, the courts have said that's fine. But here now, this is different.
I know.
This is saying, wait a minute, you know, I can use your silence against you and tell the jury that
Right.
you didn't talk to me.
Right.
That's not a misstatement about facts. That's really telling him that's what's going to happen at your trial. I'm going to be able to
Sure.
get on the stand and tell these jurors that he was silent. That's
Sure.
And so you're saying that
It-
go and it's just a matter of just what, do nothing to that at all?
Well, Your Honor, I agree with you that it's a different kind of misstatement. I guess the way I would think about it is many of the cases involve misstatements of fact. So your
facts.
co-defendant could, this is a misstatement of law. That's the way I
No,
would
it's not
think
a
about it.
misstatement of law. I mean,
It's coercive on the
Yes.
face of
Well,
it.
I don't think it is inherently coercive. Again, there's no per se
how in
rule
the
that it's
world would that
coercive.
not
and
be, how would that not be coercive? And say,
Sure.
listen, well, you can remain silent. I told you that. You have a right to do that. But you know what? But I can tell them,
I
and it's
understand.
going to hurt you at trial when I tell them you remain silent. That's not coercive.
It's not coercive because I think you have to look at it in context of the entire interview. And if you look at the context of the entire
Well, it shouldn't
interview,
have been done. We all agree with that.
I'm agreeing that. I'm not.
It's a question of how whether it has any impact on this prosecution.
It is a relevant circumstance that this court and like the district court should take into account in deciding voluntariness. But our view is it's not inherently coercive. And Judge Gregory, part of the reason why we're taking that position, if you look at this, the transcript of the interview, this is a defendant who wanted to speak. He was willing to speak. He spoke for many pages and many hours before we got to this misstatement. But clearly, he was trying to get in good with the detective. He wanted to know what his options were. This is not a situation where you had a reluctant witness who didn't want to talk, and the cop said, hey, look, if you don't talk, I'm going to come forward and tell him you didn't talk. This is someone who wanted to talk. Did the misstatement factor into his decision to speak? Perhaps. We don't know. But what we do know is, as a legal matter, that misstatement alone is not inherently coercive. When you had, it didn't overbear his will as a matter of law when all the other facts in the record suggest that this was voluntary, he was willing to speak. So I think you have to look at it from that standpoint. And the one thing we do know as far as the outer limits, under the Supreme Court's decision in Frazier versus Cupp and this court's 2012 decision in, it's either Whitefield or Whitehead, White something, that there's no per se rules here. We have to look at the totality. The district court did exactly that. It weighed the factors that supported a voluntariness finding against the ones that supported the negative misstatement.
So can you walk me through how you'd analyze a hypo that, this is bad, but a hypo that would trouble me even more? Imagine that an officer comes in and basically literally negates the Miranda warning. Say, yeah, my partner gave you these warnings, and yeah, But everything, that was all BS. That was all BS, buddy. Anything, and just, so how would you analyze a situation? I mean, I know courts would probably analyze that as voluntariness, but I think what I struggle against is voluntariness doesn't seem like a good fit. It's more like you're negating the Miranda. So how would you analyze a situation like that where, and I'm positing this isn't that case.
No, I understand.
How would you analyze a situation where what the officer said instead was all that Miranda stuff was a lie?
Right. That's a good question. Whether you would view it through a voluntariness lens or whether it would have some other, I don't know.
I don't know where it would go doctrinally, but it doesn't.
Yeah, something under the Fifth Amendment again, part of the premise, and I understand you're not saying this is this case, but part of the premise here is that it's even more difficult to show involuntariness because we have a valid Miranda waiver. If you have misinformation about a Miranda, you would take that sort of bedrock, that threshold point out of the case, and then maybe the standard wouldn't be as strict for finding involuntary in Your Honor's hypothetical. But let me also I want to just pivot to an important point. Even if the court were to decide that the statement was coerced, and I submit it should not, but even if you were to find it or you to just choose to bypass the issue, any conceivable error in admitting that statement would have been harmless on the facts of this case. And the reason why is we had overwhelming evidence that Mr. Ordóñez Zometa was involved in every aspect of this horrific crime. He is the one at the very beginning that summoned everyone to his home. He is the one that told the juvenile to bring his papers because he suspected that he was snitching and talking to the police. When they were at his home and they were partying before the murder happened, he is the one that spoke on the telephone to Pinguino, the MS-13 leader in El Salvador, who subsequently green-lighted the murder. After that phone call, Ordóñez Zometa
The murder
was
was
the one.
green-lighted from El Salvador by the boss man in El Salvador.
A boss man, yes.
And this is the key guy in the U.S. that you're talking about. You're saying.
Yes, yes.
You're saying he's the key guy of these
Yes,
three.
he was the point of contact, correct. And then.
By telephone.
By the telephone.
They did it by telephone.
By the telephone. And then once he got the order to green light, he then told his two co-defendants and others to go, well, one of the co-defendants to go upstairs and get the murder weapon. And then when they got the murder weapon, he's the one that instructed everyone to torture and mutilate and absolutely maim this juvenile individual.
What did that murder
who was killed.
weapon look like?
I'm sorry?
What did that murder weapon look like?
There's a picture of it in our brief, Your Honor, but it's basically a glove that goes over one's hand, and it has three blades that stick out from three fingers, kind of like an action figure, but a real-life blade. A three-headed blade, if you will. There's a picture of it in our brief, but that's what it looked like. And they took turns. I think the autopsy report determined there were something in the neighborhood of 150 stab and puncture wounds. And then after the murder.
And they were killing this kid, he was 16 years old or something, because they thought he was cooperating with the police.
Correct, and that was mistaken. His interaction with the police was that he was a juvenile runaway. Yes. And then the last point, of course, is that after the murder, Mr. Ordóñez Zometa told some of the defendants to stay back and clean up his house, and he told other defendants to put the body in the car, drive it to Virginia, and get rid of it, which of course they unsuccessfully attempted to do by setting it on fire. Thankfully, a Stafford County detective was able to locate the body, and because the corpse had not been completely incinerated.
Body was burned down along a highway somewhere in northeastern Virginia.
Correct. It was on a side road by a campfire. So even if you believe that somehow the statements that he made, which were certainly probative, and we believe he was entitled to admit at trial, you have overwhelming evidence of his guilt, and so any error in the admission of those statements would be harmless. If the court has no additional questions on that, then let me just wrap up my time
That's
this
the
morning.
standard here, if the issue is preserved, we have to decide whether it was prejudicial error or harmless error, if it's an error.
Yes, if it's an error, then it would be, the government's burden would be to prove harmlessness because the
And
issue
if
was
it's a
preserved.
harmless error, we can disregard it in considering whether to grant relief to the
Yes.
defendant.
And that's right, exactly.
Now, you've done two, it's three. What about the Facebook?
On the Facebook warrant account, it's my same argument, Your Honor, that there's nothing that he identified from the Facebook account, the search of the Facebook account that was admitted at trial. And in any event, we think the warrant was adequate and the good faith exception would apply. So it's my same argument to all three of the searches, the Facebook, the house, and the cell phone.
And what was the connection for the Facebook?
The connection for the Facebook was that MS-13 members, according to the affiant, are known in particular for communicating through Facebook. They often post images that may depict tattoos or other paraphernalia, other gang-related memorabilia that would identify them and link them to the MS-13 enterprise. So It was part of this investigation to try to determine who was involved, whether they were MS-13 members.
Can I ask you how far this Facebook argument goes? So the hypothesis is we have some reason to believe there's a video of the murder. We have some reason to believe that he has social media accounts.
Right.
I mean, does that mean you can get a warrant for every single one? You can get his TikTok account, you can get an Instagram, you can get a face. That literally, the fact there is quote a video and the defendant has social media alone means I can get a warrant for every single one of their social media accounts.
Not clear to me, Your Honor. I mean, if there was some evidence to believe that they used each specific social media site, then perhaps there would have
So I
been-
guess, how critical is it to your argument that there was at least some evidence that this gang uses Facebook specifically to communicate?
I think that's certainly a relevant factor as to why. I mean, obviously, I know that the government didn't do this, and I know Your Honor's not asking, but if there was evidence that they used Facebook and we got a warrant to search TikTok, there would be kind of a disconnect. But here, this is all kind of simpatico with the information that was known to the officers.
These criminals were so sophisticated, they videoed the thing, didn't they?
There was a report that they did, that no video was ever uncovered, but there was testimony that that someone had video recorded it, that they had sent it to, I believe, Mr. Ordonez Zomeda, and that others were seen watching the video. Whether it was deleted, whether that testimony was just incorrect.
Which one of them had that good idea?
Yes.
Which one had the great idea of the video thing, of the criminal conduct?
Your Honor, it's in the record. I can't say I can remember right now, and I don't want to falsely attribute it, mistakenly attribute it to someone. If I may, just the last couple of minutes, briefly just address the sufficiency point. Judge Heitens, I think you hit the nail on the head. I don't have much to add. It is focused on the enterprise. Your Honor did quote from page 907 of the joint appendix, which is the relevant testimony from the cooperator. Just the one about the wire transfers, I would also emphasize that there was an expert witness about MS-13 generally, and this is at JA 1169. The witness was asked, does MS-13 send money back to El Salvador? Answer, they do. How is that done? And then the answer is, depending on the click in the program, each specific click has to provide a certain amount of money back to El Salvador, to its leadership, to its chain of command. At times, it can be once a week or once a month. So we have sort of general testimony that this is the practice of MS-13, and then we have the specific testimony that Your Honor referenced in JA 907. And again, as Your Honor also pointed out, many of the questions that my colleague have raised about, well, it's a little too vague, it's a little too nonspecific, that's all fodder for cross-examination. That goes to the weight of the evidence. But here we're dealing with legal sufficiency, and we do think it's sufficient. As the court also knows, I think the rideshare evidence is also evidence that bears on the commerce connection, and then of course we have the phones as well, and of course the telephone call in particular to El Salvador. So we think that it's a de minimis standard, it's a low threshold, and we think that the evidence was more than sufficient. If the court has no further questions about if the court has any questions about any issue, I'm happy to address them, but if there are no further questions, I'm happy to give back my remaining time.
Thank you very much, sir. We appreciate your work, too.
Thank you, Your Honor.
Yes, sir.
Thank you.
And all of your colleagues that worked on this case. And Mr. Berman?
Your Honor, if I could respond very briefly to, first the point on the Uber. This court has never held that a single car ride or a single train ride across state lines, say an Uber from Virginia to Maryland, a metro ride from Maryland to D.C., in and of itself proves the interstate commerce element of RICO or Vicar case. The government cites one Second Circuit case involving some mob activity up there, but this court has never made such a holding. And I think it's notable here in that regard that the government chose not to charge the counts that deal the offenses that directly deal with interstate travel, such as the 1952 Travel Act, interstate travel to commit a crime of violence, or in 1958, interstate travel.
If these fellows were traveling all over Virginia and Maryland and District of Columbia, it looks like from this record.
Yeah, I don't know.
The murder was in Virginia, wasn't it?
The murder took place in Maryland, Your Honor.
In Maryland,
Yes.
but they had traveled around Virginia, and the trial was in Virginia, in Maryland.
Trial was in Maryland, Your Honor, yes. With regard to the transmittal of money, I would simply note that the expert witness that the government relies on was an expert witness from Houston who testified only in the most general way about MS-13.
Was there objections to the expert evidence coming in?
No, Your Honor.
Are you challenging it now on appeal?
Well, we're on a sufficiency argument, Your Honor.
Is this a plain error issue?
No, Your Honor. It simply goes to my sufficiency point, which is that this expert didn't have anything to say, really, about the operations of this clique in Maryland. And in other cases, such as Zelaya, you know, the expert actually talks about the clique in the community in question, I would simply submit that this expert's testimony isn't worth a whole lot of weight. Finally, Your Honor, if I could elucidate on this for the benefit of the students here, and Mr. Ornberg has granted me a little bit of his rebuttal time, I think it's worth taking note of exactly what Detective DeLeon said, so that the students here understand the court's concern about his statements. This is an officer who has a defendant in custody. It's after a Miranda waiver. It's during an interview, and he says, "Because I'm telling you, in these kinds of situations, there's a lot of evidence, and you're going to say that, oh, you only tell me, no, Detective DeLeon, I'm not going to tell you anything." Okay, no problem. But when we go to have the case in front of the judge and the jury, I'm going to be asked, Detective DeLeon, did you have the chance to talk to Jose clearly? What did he tell you? He told me he didn't want to talk. You're a juror hearing that. How are you going to look, and how are you going to think about the person that says, no, I'm asking, how are you going to look at that person in a good light or a bad light? That's a Joint Appendix 2002, 2003. We understand the government's harmless error argument. We have not challenged the sufficiency of the evidence that the murder occurred, but this is classic conduct that is pressure, rough language, tricks, treats, inducements of the sort that the court condemned in Vance versus Borden-Kirscher. And even if the court affirms the convictions here, we would ask that the court condemn the actions of this officer in the course of its discussion of this Fourth Amendment issue. Thank you, Your Honor.
Thank you, Mr. Berman. Mr. Ornberg?
Thank you, Your Honors. I did cede some of my rebuttal time to Mr. Berman, but I'm prepared to address one thing that Mr. Rotker said to the court, and I don't think he meant to do this intentionally. There was something seized when the police officers went to my client's home on Spring Hill Lake Road Spring Hill Court Road, in Greenbelt, Maryland. They seized the cell phone. And then I went on to, in my brief, to argue that the warrant for, then the police officers got a warrant for the cell phone to download the contents, and I went on to argue that that warrant was insufficient because it lacked the particularity requirements and everything else for the obtaining of that search warrant. So there was something that was seized, and we are challenging that the warrant, all three, the Facebook account, the residence, and the cell phone. If the court doesn't have any further questions, thank you, Your Honors.
Thank you very much, sir. We really appreciate you. Mr. Byrne?
Very quickly, Your
And Mr.
Honor.
Byrne, you're the public defender in the public defender's office in West Virginia,
Yes, Your Honor.
and you got into this case on appeal to assist us and the judicial system. Is that correct?
Yes, Your Honor. Yeah, we're always happy to take a cold record case from the Fourth Circuit. Going back to a point that Judge Heitens asked about at the beginning on Joint Appendix 1879, that's the district court ruling on the Rule 33 motion, and the judge specifically says it was raised in front of the jury heard it. I don't see how that alone can justify a Rule 33 new trial motion. So there was a specific reasoning given on the new trial motion being denied.
Right, and so the reason she gave is, I don't see how that, what she calls a good point, how that alone is justification for granting a Rule 33 motion. Why isn't that a perfectly, well, in fact, not only why isn't that a perfectly plausible account of what the district court was saying there, it seems to me the most likely account of what the district court was saying there. I don't see, you raise a point, I acknowledge you raise a point, but I don't think that good point alone is enough for me to grant you Rule 33 relief.
I think because in the way the district court explains its decision, it's relying on the fact that the jury heard it and the jury made a decision. It is not saying independently, I agree with the jury.
Well, except the district court literally just said earlier that the district court was aware that it could reweigh the evidence, right? The district court didn't misstate the lead. I mean, we get a lot of cases where the district court literally just, Rule 29, Rule 33, those motions are denied. That is literally all the district court judge says. Here, the district court actually says the Rule 29 standard, walks through the Rule 29 analysis, and then pivots, I'll quote it, the district court says, the Rule 33 standard is different. The district court says that. Then the court articulates the Rule 33 standard, given that, why shouldn't we, to the extent that alone is ambiguous, should we not interpret that in a way that suggests the district court understood the legal standard, not that it didn't understand the legal standard?
Because I think when the district court makes its decision, it doesn't apply that standard. My time's up. Thank you, Your Honors.
Thank you, Mr. Byrne. We appreciate counsel's work in this case, and we recognize that it's a tough case to work on as a lawyer, probably. And we're going to come down and greet counsel. We're going to adjourn court for the day, come down and greet counsel. We're going to step out for about 10 minutes and have a meeting among ourselves. Then we're going to come back in and meet with the students for a few minutes. Madam Clerk?
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.